Welcome to Estate Planning with Bernard Law.
Welcome to Estate Planning with Bernard Law and attorney Daniel R. Bernard, founder of Bernard Law PC, serving clients across Long Island. Dan focuses on creating customized estate plans designed to protect your assets, minimize taxes, and make sure everything is handled the way you intend. I'm Leann Lyon, and today we are talking about how probate actually works in New York and what can be done to avoid it. Hi, Dan. Nice to see you again.
Hi, Leann.
So, Dan, what is probate in New York, and what does it actually mean for an estate to go through probate?
So one thing I can say about probate in New York is it's a headache. It's a headache. It's a pain in the neck, and it should be avoided at all costs. The real answer to your question, though, is probate is the process when we pass away it's the core process of determining the where our probate type assets are supposed to go. Whether that's in a probate, that's typically you have a will and it's probating that will. It's proving that this was the last will. That's why we call it a last will and testament, because you could have many during your life, but it's only the last one that we really care about. Unless the ones before it had better stuff for us, then we care about those and want to get those probated. That's an aside. But we just care about that last one, and probate is getting that last will admitted, the court agreeing that, yes, this was the last one, and appointing that person as executor under that will. And then the probate process can start of collecting all of those assets from the person who just passed away and following the terms of the will, getting those assets to the appropriate heirs.
So what type of assets are required to go through probate, and which ones typically avoid it?
Sure. So not all of our assets go through probate. So when we pass away, our assets are in two categories: probate assets, non-probate. Non-probate assets are anything that has a beneficiary, anything that's jointly owned, or anything that's held in trust. Something has a beneficiary goes directly to the beneficiary. Something's held in trust goes via the terms of the trust. And if we have a joint account, the joint account holder automatically gets that account by operation of law. So most of the stuff we have is non-probate. IRAs are typically non-probate. We have a beneficiary. 401ks, we have a beneficiary. Our brokerage accounts, even our bank accounts, we can go to the bank and we can tell the bank, we want to make this account a pay on death account or a transfer on death account, which means we're adding a beneficiary. Your kids can't go to the bank and take $20 out of the ATM, or nowadays $100 out of the ATM, but they can certainly, when you pass away, go to the bank with a death certificate and collect that account. So all of those things can be non-probate. It begs the question, what's probate? It's anything that where we don't have a beneficiary, we're not jointly owned, we're not in trust. So typically that's our houses, because our house, really, you can't have a beneficiary on there. Our house may be jointly owned with our spouse, so upon the first of us to pass away, it wouldn't be a probate asset, but upon the second of us to pass away, we don't have that joint owner anymore. Typically, that's why we want to get our houses in the trust, so we can avoid that probate. But if we don't have them in the trust, we don't have an owner, we have to do that probate to determine where is this house supposed to go now that you've passed away.
So what are the most common challenges or frustrations that people run into during probate?
So common challenges will just be we have to find the original will. We have to get a death certificate. We have to track down the beneficiaries. You might have an older will that says your uncle's the executor and you're the backup executor because you were 22 when mom and dad did this will. You got to get your uncle who's 87 to waive his right to be the executor. You got to track him down. Sometimes we have to find the witnesses because the attorney did not have the will executed properly. We have to track witnesses down and have witnesses sign statements. All of those things can add time, add complexity, add expenses, and can be a real pain in the neck.
So how long does probate usually take in New York, and what factors can slow it down?
So typically we say on average it's taking 15 months from beginning to end. I think that's if you have things going well. If we can't find a beneficiary, we can't find an executor to waive. We need to get a family tree affidavit. We can't get a death certificate. Sometimes you might have a beneficiary that died or is missing. We can't find them. all of those things are certainly going to make the estate take more than 15 months. Or if you have people that can't get along, that's certainly going to take more than 15 months. So the 15 months to me, it's on average if you have that average estate, but not all of us are average.
So, what are the main strategies used to avoid probate, since this sounds like something that maybe people want to avoid in New York?
If I haven't stressed that enough, Leann, avoid probate at all costs. But the way we avoid probate is, so I told you we want to make our probate assets non-probate assets. How do we do that? We either need to have them have a beneficiary, be jointly held, or held in trust. You could technically have a beneficiary of your house because you can create what's called a ladybird deed. It's not a good way of doing estate planning because once you have that new deed and you've put your child on that deed, you need them to sign off on getting their name off of the deed. And circumstances can change, things can change, things can go negative in your child's life, and now ownership in your house is in question. So I don't like adding the beneficiaries to deeds. Jointly held is the same concept, right? Sometimes people tell me, just add my kids to my deed. They can be joint owners with me. Same concept. What happens if they get divorced? Now is your house one of their assets? And now that daughter-in-law that you never liked wants a payout so you can stay in your house. So the best way is a trust, because a trust, regardless of whether you make that trust revocable or irrevocable, most likely, even in an irrevocable trust, we're going to be able to maintain control over that asset, where we're going to be able to change the beneficiary of it, change the trustee of it. And in a revocable trust, we certainly can change the beneficiary, certainly can change the trustee. So the trust is going to give us that flexibility to avoid probate, but also it's not in stone. Even irrevocable may not be in stone. We can still make changes if our circumstances change. One of our kids really annoys us, or one of our kids wins the lottery, doesn't need this anymore. We're going to leave everything to the other kids. Doesn't all have to be negative.
So, how exactly does a revocable living trust work as a tool to avoid probate?
Sure. So in a revocable trust, we want to just transfer the probate type assets. So what I tell people is a revocable trust, it's an alternate form of you still owning everything. It's kind of like the cash in your pocket, right? You can take your cash, you can put it under your mattress, you can put it in a bank account. It's your money. It's just where is it and how is it titled? Your house is the same thing. It can be titled under your name. It can be titled under the name of your trust. The trust is an alternate form of you still owning the property. You still get all your same tax exemptions. Your star exemption. Still get mortgage deduction on your taxes. Your children still get the basis step up at death to fair market value. It's an alternate form of you still owning everything. The key difference being the trust will not have to go through that probate process. So if you have two neighbors and one neighbor has a will set up for their family and one neighbor has a trust set up for their family, and they both die at the same time, the neighbor who set up the will, his kids are probably closing on the sale of that house 8 months from now. The kids who had the trust, if they have a cash buyer, they can close probably within the next few weeks, but most likely they're going to close in the next, depending on a bunch of different factors, how fast they can close. But it's really just how fast when they have that ready, willing, able buyer, they can close immediately. And if it's a sale within the family or transfer within the family, they can do that immediately. They can deed that house to themselves immediately and be done with it, and not have this 6-month process of waiting to be appointed as an executor.
Are there other advantages just beside the house we've talked primarily about for having a revocable living trust?
Sure. So even people who don't have any probate assets, or even people who don't have probate assets anymore. So maybe they had a house and they sold it, and now they're in one of those luxury apartments that are becoming very popular. In those situations, a revocable trust, I still think makes sense for some of my clients if you want to do some trust-based planning for your kids. So a revocable trust can be a vehicle for your kids to receive their inheritance. So even those non-probate assets, the stuff that have beneficiaries on them, you can make the trust the beneficiary, and then that account will be paid into the trust. And then we've set up lifetime trusts or sub-trusts within your revocable trust for your children. And the reason we do that is mostly for creditor protection. So if someone sues them, whatever's in that trust is protected. It's not subject to that lawsuit. Biggest one is divorce. If they get divorced, whatever's in that trust is not subject to equitable distribution. It's kept separate just for them. So that can be a nice way of getting them some creditor protection. But then the other thing could be also sometimes people have kids who are on Social Security disability or on Medicaid, and getting an inheritance would knock them off of those programs. And then they have to use the inheritance to pay for the things that were already being paid for by the government. And that when they dissipate the entire inheritance, now they have to reapply and get back on the programs. But if we have a beneficiary like that, sometimes people say, oh, I'm going to leave them nothing because it would be a waste. But we don't have to do that. We can set up a supplemental needs trust, either standalone supplemental needs trust or even just within your revocable trust, that would make it so that a beneficiary, if they were in that situation, we can protect the assets for them and just use it for the extras that the government's not paying for, and they won't get knocked off of their programs, and they can keep status quo, and the money doesn't get wasted, for lack of a better term.
I've even heard of people just being very specific with how their children, should something happen to them, are cared for, what camps they would go to, or how they would visit the other side of the family. The creativity involved in a trust is just phenomenal. I just love it.
Absolutely. That's great examples.
So can you walk us through an example, though, where someone thought that they had avoided probate but didn't, and what caused that breakdown?
Sure. So I've talked a lot about the non-probate assets and things with beneficiaries, right? But the key is, just because it's a life insurance policy and can have a beneficiary, it actually has to have the beneficiary. So I had an estate where it was very well thought out. It was a older gentleman. It was a lot of fun to work with. Very creative guy. He had a lot of creative ideas he wanted to do in an estate plan, but very well thought out. I met with him multiple times, and he brought both of his daughters, to every meeting. And the key was avoiding probate. And we got his house into the trust, and we did all kinds of other things. And then when he passed away, we still had a probate because he bought a life insurance policy when he was in the Navy in the 60s. And it was a fully funded policy. Never knew anything about it. There was no beneficiary on the policy because he bought it in the 60s. So his beneficiary was his parents, who died, 40 years ago. So we had to do a probate just for that one asset that we thought had a beneficiary on it, and actually that they didn't even know existed. So we did a probate for a $10,000 life insurance policy that they didn't know existed. So those kinds of things can come up where best laid plans of mice and men, we think we have beneficiaries and everything. It's really key when you're doing your estate planning, you're in that mode of, okay, I'm putting my house into a trust, I'm setting up my healthcare proxy. It's also important, let me make sure all my beneficiaries are up to date, are the right people that I want, that I have contingent beneficiaries on everything. Having your spouse as a primary beneficiary is not enough. Your spouse may die before you. You have to have those kids as your contingent beneficiaries. So if we don't have a beneficiary on something, it's a probate asset now. So we want to take probate assets and turn them into non-probate. We don't want to take non-probate and turn them into probate. That's a disaster. So that's the number one thing we say is the beneficiary designations.
So in the case of the gentleman you just mentioned, the one asset had to go through probate, but everything else did go through as planned. Am I right?
Absolutely. Everything else went as planned. Everything else went to his daughters directly. The house they were able to sell directly out of the trust. But the problem is, whether your estate has one asset or 100 assets, the formalities of the probate process are the same. We do have what's called a small estate process in New York State, and many other states have this. Florida has this too, where if the estate value is under a certain amount, so in this instance, if in New York State, if it's under 50,000. So in this instance, it was under 50,000. So we were able to do what's called a small estate proceeding, but it's the same. There's still a filing fee. There's still attorney's fees. You're still waiting for the court to appoint someone to be able to collect that asset. And there's no guarantee that you're going to be in that small estate, simplified process. If you have an IRA with, $51,000 in it that does not have a beneficiary, you're doing a full formal probate so it's sometimes people think like, well, if I don't have a lot, that can be more complicated than people that that have, that you think have a lot more than you. Like someone could have one house in Sag Harbor with $7 million. That's the only thing in their estate. And someone could have a $100,000 estate with 27 different bank accounts. The $7 million estate is going to be a lot easier to deal with than the $100,000 with 27 accounts. So it's not always the value that one asset can be a pain in the neck. It's just we want to avoid probate regardless.
And I think I'm clear that had they had a beneficiary, the 10,000 would have gone just straight through. They would have had it. Where going through probate, they did not get the full $10,000.
That is correct, because they had some legal fees and court fees in there to get the 10,000. So they
Absolutely. So as we wrap up today's episode, what should someone focus on right now if their goal is to keep as much of their estate out of probate as possible?
I would say if you don't have a trust and you own a home, you need to go see an estate attorney immediately, because if you own a home, I can almost guarantee there's going to be a probate unless you've added your kids to the deed, which is a different mistake. But if you own a home and you don't have a trust, let's go visit an estate attorney. And if you have a trust in place and it's been in place for a while, and maybe you've had some change in circumstances, or if you created your trust when you lived in one house and now you live in a different house, let's make sure that we have the new house in the trust, because the new house doesn't always get in the trust right away.
I may or may not know what you're talking about. Okay, got it. So get it taken care of today, because none of us is promised tomorrow. And that is it for today's episode of Estate Planning with Bernard Law. If you would like to learn more about Daniel Bernard and how to structure your estate plan to avoid unnecessary probate and keep things running smoothly for your family, visit BernardEstatePlan.com. Thank you for listening, and remember to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you, Dan.
Thank you, Leann.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.